We're basically going to have a conversation about HIPAA and FERPA and information sharing. And whoever is wanting to have that, great. If you don't want to have it, you're welcome to go into one of these rooms or whatnot, or be exposed to this conversation even though you don't want to be. We put this together just so that we could start to have a conversation about HIPAA and FERPA and information sharing. One of the things that I will tell you in the context of the ecosystem paper that we wrote is that one of the barriers that bubbled up in the research that we did across the state of California was HIPAA and FERPA. And like, what the heck are we supposed to do with these laws, and how are we supposed to navigate them? And so I can tell you that I do a lot of HIPAA and FERPA work for the public schools. When I'm building wellness centers, I've built a lot of wellness center continuums, I guess, in the schools, braiding and blending behavioral health providers, hospitals, and education. What I'll say about that work is that the people who are from the hospitals and on the behavioral health side of the house understand what? HIPAA. And 42 CFR, that's right, and 42 CFR. We have federal law and state law that's involved in all of this. And the people on the education side of the house understand what? FERPA. And the education codes that implement FERPA. You speak different languages, and we are in the midst of integrating care and integrating services, integrating those laws together and having to navigate them together when you speak different languages. And so knowing that is actually kind of important to this work, because I cannot tell you how many times I built a wellness continuum for a school district that is FERPA governed, with FERPA governed services, with a behavioral health provider, a CBO, as a contractor in the wellness center, providing the services for the district, funded by the district to district students as a contractor for the district. And the provider comes in and says, what? HIPAA. HIPAA. Like, we're not going to share anything. Like, this is HIPAA governed. But it's actually not. In that particular context, that service is actually not HIPAA governed. It's a FERPA governed service. And the information sharing that's happening there is governed by FERPA. So I tell you that to say that, well, a couple things. One is, in the context of a half an hour, 40-minute conversation, we are not going to dive into all the intricacies of HIPAA, FERPA, California laws, all the federal regulations, and how to navigate all of them. It's like any of the other conversations we've had at this conference. We're presenting you information to take it back, to go back and have these conversations and figure this out at the local level. The other thing is, to the extent, someone just came out to me with a question, to the extent you are grappling with a particular scenario or issue, the lawyers that you're working with can be very helpful, but I will tell you that education lawyers know FERPA and behavioral health lawyers know HIPAA. So you got to get your lawyers together, because we have to get on the same page about how you're going to do this, how you're going to build your integrated care continuum, and how you're going to navigate HIPAA, FERPA, federal and state statutes that implement those in order to information share in the ways that you and parents and youth and families want and need in order to better serve them. So this is kind of a 101. But the other point of this conversation is really to figure out what you're struggling with. So if you're sitting here and you wanted to have this conversation, one of the points of this is for us and our partners to gather information from you about the barriers you're facing and the questions that you have to do this work. Because if we gather that information, the state is developing state health information guidance on HIPAA and FERPA and how to navigate all of this for all of you, and training on that. So if we don't have the scenarios, the questions, the challenges, then we can't make sure to incorporate that information into the state health information guide. We also can't make sure to incorporate into any other broader technical assistance that might be provided at the local level as you're doing this. So that is these are the purposes of the training, and I am going to get into what is HIPAA, what is FERPA. Some of you, as pointed out over here already, are expert in these laws. Some of you are new to these laws. So we're just going to talk about, 101 information on the laws. So we're brainstorming, like, what information might a health provider want from others to provide better care? What information might others want from the health provider? What are the most common scenarios that present themselves in your work in this area? And I really want you to think about that, because we're going to ask you that question at the end of this so that you can give us the most common scenarios you're facing so that we can work to answer those either here or in subsequent work. And what questions do you have that they present? So be thinking about that. So why does information sharing matter? I mean, it seems super obvious, right? We have expectations of privacy for certain information. Protecting privacy improves access. Do we all come back all the way back to Carla, right? Carla spoke at the very day one about, you know what? I'm not necessarily going to sign that form for you to treat my child or share information unless I have what? Trust. Unless I have trust. A lot of this comes down to trust with the people that you are asking to share this information, and trust in the people that they are giving it to, that they are not going to misuse it or abuse it, right? But the other thing is, who else needs trust? Parents need trust in us. Youth need trust in us. Who else needs trust? You need trust in each other. I cannot tell you how many times someone who is working in a school setting says to me, I'm not going to share that. Why? I don't trust them. They're going to use it the wrong way. That's not a legal issue. Is that a legal issue? That is not a legal issue. That is actually a breaking barriers issue. That is you need to build trust on the ground in your local setting with one another and with your families and youth to know what information you need to share, to know what information you're going to share, and to know that you're going to use it in a way that doesn't abuse it. That is the basis for this. And it actually shocks me how little trust we have. And I do not mean parents and youth to us. I mean between us. So that is something that if you take anything away from this, go home and build trust and talk about your information sharing and what you want to share and why you want to share it and how you can do it with trust. We have tension between disclosure versus privacy. That's a common theme in this work. And one thing that I'll say is HIPAA and FERPA and the implementing laws all allow exchange of some information. They do contemplate information sharing. Every single one of them contemplates some level of information sharing. And I think you have to remember that this is complex because it's not just HIPAA and FERPA. It's HIPAA and FERPA and a whole bunch of other law that is at play here. And California has a whole nother body of law around minor consent services. Not everybody has that. We have laws that say a minor, 12 or older, under certain circumstances, can access care with whose consent? With their consent, right? And so I will just tell you, I am not going to get into the details of HIPAA and FERPA and minor consent in a really detailed way during this conversation, but I was just telling some people, minor consent in the context of what we're talking about requires a lot of intentional conversation. How you are going to provide minor consent services in your local areas requires its own intentional conversation. Who's going to do it? Is it HIPAA governed or FERPA governed? And what information is going to be shared? With who, how, why, for what? So do not, the first thing I do when I start building a wellness continuum in any education setting with all the partners is say, I want everybody in the room. I want the school counselors in the room. I want whatever MFTs and LCSWs you've hired to provide services on your campus, CBOs, I want them in the room. I want your outside providers that you're referring to, I want them in the room. I want your teachers in the room. I want everyone in the room to know how we're going to provide this continuum of services, whether it's HIPAA governed, FERPA governed, and how we're going to information share, and what the privacy, who's going to see what, right? And for what purpose? And all of that is extraordinarily intentional work. There are so many situations where we are propping up wellness centers and wellness continuums and braiding and blending services across behavioral health and education. And now we have the new fee schedule. And guess what no one has talked about before they do it? HIPAA and FERPA. Literally, I can't tell you how many scenarios where they prop up an entire infrastructure for wellness services across a whole bunch of people, and then a fight starts after the fact over what's going to get shared, how, who, when, why. That actually should not happen. Though all those things should have been considered in advance of you beginning to your partnerships and your deployment of those services. And it's totally doable. This is all doable. And both laws contemplate information sharing. It's just intentional. So, and every scenario is very fact specific, and I'm going to show you why. There's a couple of resources that I've been involved in creating. One is HIPAA or FERPA, a primer on sharing school health information in California. I did that with Rebecca Gudeman from the National Center for Youth Law. That is out in the field. It is available to you. Both Rebecca and I are available to you. If you are struggling with this and you want answers, you are more than welcome to contact me, and you're more than welcome to contact Rebecca at the National Center for Youth Law, and we will try and provide those answers to you. Make sure you hire lawyers that understand HIPAA and FERPA. We also have School-Based Health Alliance online toolkit. Lisa's sitting right here and was at the School-Based Health Alliance, is now at WestEd, and that's on health and information sharing. So those are helpful documents for you. The tension is, for successful collaboration, there needs to be a communication mechanism that allows for timely dissemination of information to all the agencies and stakeholders. And then protecting privacy and maintaining confidentiality are essential and legally required under FERPA and under HIPAA. So as I just said, the challenge can be navigated through careful planning and engagement. But under what conditions can we share? Can we always share? No. You can't just willy-nilly always share everything. What is the strongest mechanism to be able to share the information that we want to share? Consent. Consent. HIPAA and FERPA have consent provisions. HIPAA and FERPA both have consent provisions. If you have consent by the holder of the information to share that information, you can share that information. And in most cases, when we ask for consent and we have trust, people share the information, they sign the consent in order for us to share the information in the ways that Carla wants. So I have Solano up here. They've built a very robust partnership with behavioral health and wellness services throughout the county over the years. And they are providing those services in that partnership. So I just wanted them to talk for a second about how they're sharing information in their processes. So Camden, do you want to speak for a second?
So yeah, we're the County Office of Education, and over the past 4 or 5 years have gotten multiple contracts. And so what we've learned is some of our programs are HIPAA and some of our programs are FERPA. And so some of our clinicians who are in different cost centers may be HIPAA on one day and FERPA on another day. So we are funded by County Behavioral Health to provide a school-based mobile crisis center. So we're going into local schools and doing risk assessments with suicidal students. And so under that, and it's interesting because we sought out legal consultation and actually disagreed $10,000 later with the information that was given to us and said, no, I'm pretty sure we're HIPAA governed in this situation, given that we are funded by a county behavioral health entity to provide this service. And then we have other programs where we're pushing into schools. We are a county office of education. The funder is an educational entity paying us to provide mental health services, in which case we're FERPA. And so I think what we've really learned, what I've learned as a leader, is that clinicians, it's drilled into you. They don't, grad school did not teach me about FERPA. That was not on my exam. And so when I have a school talking FERPA, I'm like, that's not me. And that's my staff. That's not us. It's got to be HIPAA. And so teaching them, we got to be flexible because the landscape is changing. And we have to be relational, as Elizabeth was saying, that it really comes down to we have to build those partnerships with our principals, with our teachers, with our community partners, so that we know that they're not going to misuse that information when we share it on behalf of a student, because we have to be able to share to advocate on their behalf so that the teachers know what is going to benefit that young person when they're becoming dysregulated. What have we practiced in therapy with them? So not that we're giving them the nitty-gritty of the young person's background and trauma history, but giving them the skills so that they can be successful in the classroom or whichever milieu it is. So I think just flexibility, encouraging our clinicians to be outside the box, and coming together. And as you said, having these conversations ahead of time, we absolutely didn't. We just kind of assumed. I went in there, we're HIPAA, of course we're HIPAA, we're mental health, until we started having parents saying, okay, we want to see our kids' CUME file and where's the mental health services that they're receiving. And so we were having to quickly get on the phone with lawyers and determine what do we have to do. So don't do that. Have the conversations first and foremost so you know what the guidance is going to be. Dr. Parr?
And I would just add that, and I'm here to ensure that I'm advocating on behalf of educators who don't know anything about HIPAA or FERPA necessarily, because when you think about it, it's site administrators who are supervising the school psychologists and the counselors, and we need to make sure that we're putting information out there for them to be able to help lead, since they're in that leadership role, and to encourage the conversations, to know who to speak to as we continue to build out this ecosystem. And there is lots of moving parts and lots of different funding and contracts and things that have to be navigated. So we need to make sure that we have entry points for everyone within that ecosystem to understand how to better facilitate the relationships necessary for us to do this work.
Do you get consent to treatment and information sharing in the context of your services? So you need to have a process for consent to treatment and consent to information sharing in the context of your services, period. HIPAA governed, FERPA governed. You should have that baked into your protocol. You should have those forms, and that's actually what I do. Is I say who's here, what is the continuum, what laws are governing this, and what are our forms and protocols going to look like for information sharing. And oh, by the way, how much information are we going to share, and where is it going to be held, and who gets access to it. And the other thing that I'll say is no matter which set of laws you're operating under. So I told you earlier, so I'm a mass shooting survivor and former hostage of probably the longest hostage crisis, domestic hostage crisis we've had. And I'm I have PTSD. And if there's a loud noise in this room right now, I'm out of here. I can't even tell you that I'll be out of here because I don't know what I'll do. I might be under that table. I might run out that door, but I can't tell you what would happen. I might try and run through that, which is a wall. I don't really know what I would do, but I'm going to be dysregulated. That much I know. And that's not intentional. So if I'm receiving treatment and I'm a child and I'm in a school setting and this is my reality, my teachers and other staff need to know that. What do they need to know? They need to know that if there is a loud noise, Elizabeth is going to dysregulate, and she's not doing that intentionally. It's not a prank. She's not a jokester. She's not trying to disrupt your instruction or the playground or whatever when she starts screaming and yelling and freaking out. If there's a loud noise, she's going to get dysregulated. And these are the strategies that you can use to help her center. Do they need to know that I'm a mass shooting survivor and former hostage for 10 hours? They don't need to know that. So a lot of times people want to know everything. And I just can't emphasize enough when I do trainings and when I talk to people here about, think about what you need to share to holistically support that child. I can tell you right now, I have done audits of systems, of the records that are kept. Even in the ARIES, the educational, big ARIES system with no privacy settings on this particular function. And some of the information that I've seen scares me. But the same is true for clinicians from, behavioral health who've come and provided services, and they're putting it in a context and sharing information like what I just said, that I'm a hostage, that I was with a gunman, that I was there for 10 hours, all of that in there. And that doesn't need to be in there. What needs to be in there is Elizabeth is going to get super dysregulated if there's a loud noise. She is sensitive to this. So thinking about what we're recording and then who gets to see it is really intentional and really important. And I can't tell you how many principals have said to me, I need to know everything. And I'm like, do you? And I use myself as an example constantly. So we've got HIPAA, we've got FERPA. I'm just going to do a quick, is this covered under HIPAA or covered under FERPA? And it goes into a funnel and we make a decision. This is not meant to tell you, bye ladies, this is not meant to tell you that everything ends up being FERPA. This is just meant to tell you it's an analysis that we do. HIPAA, FERPA, what is this record going to be governed by? HIPAA limits disclosure of health information maintained by most healthcare providers. Healthcare providers is a broad term, can mean physicians, clinical social workers, medical mental health practitioners, hospitals, clinics. Applies to providers that provide, bill for, and are paid for healthcare, or for individuals as they're transmitting health information in an electronic form. Its purpose is to protect information, to limit disclosure of protected health information, PHI. PHI is defined as individually identifiable health information in any form, including oral communications as well as written or electronically transmitted information. Healthcare providers can't disclose it without a signed authorization, with some exceptions, and I did not list them all. but they may share some protected health and mental health information with other healthcare providers for treatment and referral purposes without the need of a signed release. You can always share with a written release of information, and that's exactly what they're doing in Solano. So that is going to become, hopefully, an integral part of your service delivery system. FERPA. Now we get into FERPA. FERPA limits disclosure of personally identifiable information in education records maintained by school districts. It provides parental access. It is the Family Education Rights Privacy Act. It provides parental access to education records, which includes records maintained in any form directly related to a student that are maintained in the regular course of business by the educational agency. There are exceptions. We can share protected information with other school officials who have a legitimate educational interest in that information. Is that everybody gets to know everything? Right. So you got to have a legitimate educational interest in that information. So when a principal says to me, I need to see everything on everybody, what do I say? I say, there are probably, let's look at a school with 2,000 children, right? So 2,000 children, that principal may never, ever, ever have any contact with some of those children, right? Never. Now, in an emergency situation, they may need to access information about that child, but as a general course of business, they don't have a legitimate educational interest in all of the information for everybody if they're never, ever, ever going to see that child, if they're never going to interface with that child. So thinking, and plus, they have a legitimate educational interest in what I just said, the information necessary to educate, right? Not all the intimate details of the therapeutic relationship or what happened. And so really having those conversations like, what does that legitimate educational interest mean? And then who's going to have access to information when they need it, particularly health information? There are privacy settings in all of our databases. When people need the information, they should access the information. If they don't need the information, they shouldn't. In some of the work that I've done, I've created a box. Before that information opens, it says, I have a legitimate educational interest in this information. And then they access it because it's like this intentional decision that you're making. If we hire an outside mental health provider and they think HIPAA, they aren't necessarily governed by HIPAA. If they are operating as a school employee, if we hire them as a school employee to provide services in schools to students in schools with our dollars, they are FERPA governed. FERPA governed service, FERPA governed for purposes of records. Contractors and consultants for schools can be employees, legit school officials, but in order for that to happen, our local board policy has to define school official to include contractors providing services for us. We also have to define legitimate educational interest. And then those providers are operating under our contracts with them, which also have information sharing clauses, hopefully, and FERPA. FERPA says outside of a legitimate educational interest, we need written permission for the release. So that's either by the parent or if a student is 18 years or older, by the student. And I put the definition of parent. Education records don't include oral communications and sole possession records. And sole possession records are controversial, but they are records kept in the sole possession of the maker, used only as a personal memory aid and not accessible or revealed to any other person except a temporary substitute for the maker of the record and not considered. Those are not, that's an exception to pupil records, to FERPA records, the sole possession records. So people will say to me like, all this stuff, it's sole possession notes. These are all sole possession notes. And then I give them to Camden, and Camden and I talk about them, but they're my sole possession notes. Exactly. Not anymore. The exception under FERPA and California law for sole possession notes is that they actually maintained in a sole possession of a human being and not shared with other people, except in the context of as the statute says, a temporary substitute. I personally think that, as we're breaking barriers, we need a new body of law around this sole possession notes and records. Like, this was written before the world today. So I am thinking a lot about, what might those new policies look like. But this is the current state of the law now. So they can't be shown to anyone else. They can't be maintained as a pupil record in the pupil file, and they have to solely be used as a memory aid. You have to think this through. If you are working in schools or in a school-linked continuum and you're operating under FERPA with a legitimate educational interest and sole possession notes is part of the consideration because you want your notes to be sole possession notes, you gotta intentionally think this through. This is its own body of work that we need to be doing in the field. So what happens when you put HIPAA and FERPA together? Is it just like, I don't know, what's the acronym that goes together? FERPA? No. We could just come up with like a blended, but the reality is they don't apply to the same information at the same time. That's the federal guidance that we have, right? So private health information under HIPAA does not include the information subject. It's just the same document. The document that's HIPAA governed is HIPAA governed. It's not HIPAA and FERPA simultaneously for the purpose of that one piece of information. So these are intentional decisions that we have to make. This is actually straight out of the US guidance. A school mental health program's information is subject to HIPAA if the program is funded, administered, and operated by or on the behalf of a public or private health, social services, or other non-educational agency or individual. A school's mental health program's records, like our nurses' records, are subject to FERPA if the program is funded, administered, and operated by or on behalf of a school or educational institution. What about when you have the blend? We are blending and braiding right now. We are neither one of these in most of the scenarios. We are blending and braiding. We are schools paid by behavioral health to provide services with their employees or our employees. These blended and braided infrastructures that we're building require an analysis of whether you're going to be HIPAA governed or FERPA governed. You have to sit down and have that conversation and figure that out. In a situation where it is so complex that it is essentially 50-50, you need to make these decisions in your local context with your attorneys. And that is literally part of what I do for work. Well, my law hat work. Critical to all information sharing is informed consent to disclosure. I cannot emphasize this enough, and what I put here is like how, under what is like a legally compliant consent to disclosure form, have to include and look like. But I am a massive proponent of consent to treatment and consent, or release of information, consent to disclosure. It comes back for me to what Carla said, which is I want to know what you're sharing. I want to know who you're sharing it with, and I want to know why you're sharing it. And I believe that that's important in the work that we're doing, and in the access to care. Because if we don't have trust, then we can't provide the most meaningful services. Minor consent services I already talked about. It's really a separate, you need to be thinking intentionally about minor consent services independent of your other services that are parent consent services. Okay, HIPAA, FERPA, consent. This is just broad. I didn't even get into there's a lot of California law that needs to be considered here as well. But what we want to do now is have a conversation. So you're in this room for a reason, and I'm not entirely certain what that reason is. But for those of you who want to share a question, a barrier, a context under which you're really struggling and you're looking for answers, we want to have that conversation. And I'm going to invite third sector. So I haven't even introduced third sector yet. Third sector is sitting at table 8. And they are a consulting firm that just picked up the state health information guide that is going to be written and published on the new fee schedule. And on HIPAA, FERPA, and information sharing within the context of all this billing that we're going to be doing. And so as they develop that publication, and I'm going to help them develop that publication, which is coming out when is this? End of 2024. We are brainstorming the scenarios that the field needs answers to so that they can be put into that. And so they're here to listen and to gather information from all of you about what you need answers to. Okay, so who wants to step in here and ask a question or just tell us something? Why are you here? What is the information that you want an answer to? Yeah. Can you? There's a question in the back, and then we'll just kind of keep, yeah.
We'll keep going. All right, I saw your hand first, and then we can go into the back too.
Let's see how why I'm here. I'm here because I oversee all of the counseling programs in my school district, and I'm in the middle of SBHIP, and we have on-site mental health clinicians employed by the district as well. We contract with our community partner, PVPSA, who we have clinicians who come in. And some of the clinicians that we hired, this was before, some of them have LMFTs, some of them have LCSWs with a PPS. It seems the LCSWs with a PPS understand about sharing information when as needed, better than the LMFTs. The LMFTs, constant response when we need a little more information. If we're in an MTSS meeting wanting tier 3 interventions, need to do more. They say, no, I'll lose my license if I share information. So obviously it's nice to have these documents so that I can help, speak with them about that. But that's pretty much why I'm here, because that's a constant battle. And now some of that is coming from some of the PPS school counselors. And they are, they're not under I don't believe they're under HIPAA, the way that the health providers are, but they get confused and think now they can't share. And so we're going back to trust, right? Making it clear. I really appreciate just doing that with them and making it clear of what we're sharing for who, when, all of that. A big question, this may not be the place, is TerraSoft. So when a TerraSoft issue comes from, like if a student is revealing, wanting to harm another student to our school mental health clinician, they usually would go to the administrator first, and the administrator would do the assessment and see if they have to call the police, if it's, do the risk assessment. And then when it's the partners believe that they would go directly to law enforcement and send the police to the school, which we're trying not to have happen. So is there a particular law around that? Like if depending if a student is speaking about harming another student to an outside partner versus the PVU, the district employee, when it comes to reporting about harming? And I don't know if this is too out of the FERPA.
You can be my person.
Yeah, I can speak to what we've come to do. So we have our school-based mobile crisis, and we frequently respond to homicidal ideation. So TerraSoft comes up relatively frequently. So what we've done is contracted with a former law enforcement expert who can bring that law enforcement lens without us having to go directly to police. And then we have administration. So we see it as a triad. We want mental health, law enforcement, and administration looking at all of those homicidal ideation cases just to ensure that we don't have kind of some mass event. And so that's where we, after struggling with the first year around when do we bring in law enforcement, when do we not, we kind of have law enforcement at the table, and he's really able to guide us. So that's how our agency. Mm-hmm. Correct. Correct.
Yeah, I would just say that one of the things that I do when I do my consent forms for wellness continuums is to include all of the different partners that are consulting regarding care for a student, and list all of them so that they know who we may be consulting with. But that has to be baked into your team instead of 911 being the solution. There was another question in the back, and I know it's 1:45. Wait, is that right? It's 1:45. So we're over. I'm happy to stay and answer. I want to answer the question in the back, and then I know that third sector had some questions they want to ask you, and then we're gonna take off now that we've solved all the world's problems, right? No, we're getting there.
Thanks. And I don't really need to discuss this, but I'd like third sector to look at it. Increasingly, county behavioral health is being required to integrate substance use disorder services, which is then going to move into the schools. And they have even stricter sharing laws under 42 CFR, which is what I brought up, sort of yelled out earlier. And I think it's important to start bringing that into this conversation, because those services are going to be coming into the schools too. And that's minors only sign for themselves. That's, you have to list every agency separately. It's like much more restrictive in what the paper looks like, and quite different than what the paper looks like for HIPAA or FERPA. So, and different in who you talk to get the consent. So parents can't get anything without the student agreeing to it. Just something I think that would be beneficial to add.
Yeah, I'm plussing one on that for sure. Yes, you can do a universal consent to release. You're gonna want to work with counsel that understands what you're doing, but yes, you can have a consent to release. I've written a number of them that have the partners that are going to be sharing information, and the information that's going to be shared. And again, like to the point of substance use, like that's coming into the schools way more. It used to be like we referred out and then that's it. And it was awful, frankly, because how many cases did I have with children that were like substance users who just were back on campus? And I'm like, what's going on with their, treatment? Like, how's it going? Because we don't want to expel them, right? Like, and so having that is great, but it's going to create a whole nother question about how we're information sharing. But yes, consent. And actually, I wish Daniel Stein was here, because a new innovation that we have sort of like percolating is a universal consent to release like database that he's been working on both with California and the federal government. I think it's SAMHSA, to develop some sort of universal consent to release that can be populated by us. Within the context that we're in. And so that's like coming soon also. So, but yes, that can be built for sure. I think they are piloting one, and I can tell you, is anyone here from San Mateo County? No. San Mateo County put a lot of time and energy into a universal consent to release years ago. They sent an entire team to Georgetown to do interdisciplinary work on what a universal consent would look like across education, behavioral health, juvenile justice, welfare. Super complex, by the way. I'm talking about HIPAA and FERPA. The laws surrounding sharing with child welfare and probation are also an entire other body of law. And so anyway, they did create a universal consent platform that self-populated, and then it didn't get, I don't think, someone can connect me if I'm wrong, but it didn't get utilized by the system. And I think it was because it was built in a vacuum by part of the system. And when that's another thing I'll say, when something's built in a vacuum by part of a system, like the rest of the system is not going to just go pick it up and start using it. So, if you're building that sort of infrastructure, you're going to want the attorneys from the different partners to be there. the other thing that I'll say is when universal consent means something different to everybody, by the way. Every single person in this room is thinking something different when you say universal consent. So the consents that I've built are consents to wellness services and the continuum of people that are going to be involved in that wellness service delivery system. A broader universal consent might be something people are talking about as well. So yes, in the back. I'm just going to jump in, because what I'll say to that is, like, not to get into the context of everybody's continuum and their services, but I'll just give you a good example is, like, sometimes we have school-based health centers. They're on our campuses, and their HIPAA governed services are run by the behavioral health department. They're providing health services for students through referral on the campus, but they're HIPAA governed services. And then our wellness services, where we've hired CBOs and contractors, are FERPA governed services if they're funded by us and But in the situation which we have way more of now, where county behavioral health is hiring clinicians that are coming onto our campuses to provide services to our children through referral by our staff, that can be a blended situation enough that, like I said, you're going to be making an intentional decision whether your services are HIPAA governed or FERPA governed, because it's just so blended. It's more complex than follow the money. So it isn't just about follow the money. So that's why Rebecca Gudeman and I will be working on this state health information guide. But what I'll tell you is it's multiple factors. Who's employing them? Who's giving the money? Who are they serving? For what purpose? Which is why I say it's a really local, fact-specific, intentional decision that needs to be made with the attorneys that are developing that. And everybody in here has a different scenario. I wish I could say it's black and white, but yeah, there's HIPAA, there's FERPA, there's California laws, there's minor consent laws, and there's case law. Which is why, like, often I'm training and people will say, like, well, you know, I have this very specific scenario, and that's kind of the only way that I can answer their questions is to be like, when I'm giving a training like this, oftentimes people will come up with a very specific scenario, and I'll be like, okay, but I'm not your lawyer to answer that question for you because it's such a specific question in a specific context. So you've got to go back and make these decisions. Like all the information that we've gathered here. We're not going to replicate everything that we've heard, but we're going to build shared information, shared data, shared goals, shared outcomes, shared leadership, shared financing. That's all going to be in your local context. Next year, I'd like to have this where we all just sit here and get all, like, literally we have like consultants and everyone can ask their questions and get all of them answered. Wouldn't that be cool? Yeah, and I so appreciate you sharing the things that are gonna really need to go into this guide, which is why I say minor consent is its own body of work that we're really gonna have to think through in the context of this new fee schedule and providing all these services in school-based and school-linked continuums, which we will do. We will do. It can all be done. And with consent. One more question, and then we're closing down the Breaking Barriers Symposium for 2023. Thank you so much. I mean, you guys are all just extraordinary, honestly.